This Courtroom case takes a shocking turn right from the start. A man charged with a serious third-degree felony involving family violence and strangulation is about to accept a plea deal, but suddenly, everything changes. Instead of a straightforward sentencing, the defendant claims he didn't even commit the crime. Is this a desperate attempt to avoid prison, or is there something deeper going on here? Stay till the end, because the judge's response might surprise you and could completely reshape this case.
Violence. Did you understand that to be the plea?
Yes.
Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
At this point, the court is confirming the plea agreement. 3 years with community supervision, along with strict consequences like losing the right to own weapons and even restrictions on child custody. These are serious legal outcomes tied to a family violence finding, which stays on record permanently. But here's where things get intense. The defendant suddenly starts explaining a completely different version of events. Instead of admitting guilt, he's suggesting someone else caused the injuries. So now the question becomes, why accept a plea if you're claiming innocence? Was this pressure, confusion, or strategy?
It says it's over household chores.
It wasn't over household chores, but
What was it over?
a friend of mine had passed away and his wife needed some money. I loaned her some money. I wasn't asking back. I wasn't asking for the money back. Lauren, which was my girlfriend at the time, was very angry with that. She got into an altercation with her, and after they fought, I kind of was like defending the other girl. I called my friend to take Lauren to the hospital because she was busted up, and I was at home, and in the morning, I had the cops at my door saying that I did all this stuff.
So you're saying you didn't do this?
I did not put my hands on her. I did not strangle her. I have 2 daughters. She's very aggressive. I don't hit her back or anything like that.
So you're saying this happened because she got in an altercation with someone else?
Yes.
And who was this person she got in an altercation with?
Her name was Lisa.
Well, I mean, you loaned her money, right? The person
Yeah.
so who did you loan money to?
It was my friend Philip's wife.
Oh.
He passed away on December 23rd, and she was just going through some hard times.
But no. What's her name?
Lisa,
Okay, Lisa what?
I don't know her last name.
Well, there's a person here listed as Julissa Anguiano.
Oh no, that's my friend's girlfriend. She has nothing to do with the case. Nothing at all.
All right.
Yeah, nothing to do with it.
So defense, he's saying that somebody else beat her up.
I explained the whole situation, Judge, where we're at currently in this phase. In terms of the court proceedings, I'll ask the client if you wanted me to reach out to the state for an offer, if you wanted to not have a jury trial in this matter. His concern, I believe, is as well that he's been in custody for some time without the ability to make bond. So when referencing all of that, we did confirm and reach out that the complaining witness does not want to move forward with the case. There's been an A&P tendered.
This is the turning point of the entire hearing. The defense reveals something critical. The alleged victim doesn't even want to move forward with the case. That alone can weaken prosecution, but it doesn't automatically dismiss charges. What really stands out is the judge stepping in and addressing a major issue, pleading guilty just to get out of jail. This happens more often than people think, especially when defendants can't afford bond. The judge is clearly concerned about fairness here and makes it clear no one should admit to a crime they didn't commit just because they're stuck behind bars. That's a powerful moment.
your plea and I found there was sufficient evidence to find you guilty. But what I can tell you, if your counsel decides that you all are going to proceed a different way, I'll allow you all to orally, if there's no objection from the state, do a motion for new trial and we can start back over.
Yes.
All right, so we'll recall this for Thursday.
Thank you, Your Honor.
Thank you,
All
Judge.
right, thank you.
Well, she did it one time, but she has a very bad temper.
And Judge, in speaking with my client, I did tell him that I would gladly assert his defenses and have a jury trial. But he wanted me to get him the best offer today, and I did go over all the stipulations. So I believe that's why he wanted to proceed this way outside my guidance, because I asked for more time to get ready to.
Well, if you all want to, this is what I can do. Because I'm going to require a TAP evaluation for you in custody because I need to figure out that's for 2 weeks. That's how long a TAP will take. If y'all want, we can bring this back on Thursday or we can bring it back on Monday. That'll give you more time. I don't want somebody to take a plea because they want to get out of jail or they can't make bond when those issues can be addressed. If you're telling me that somebody else did this wasn't you,
Yes.
then, you need to give your attorney a chance to find out who this other person is. Who knows? Maybe they'll come in and testify, give some information to the state. I don't think the state, and correct me if I'm wrong, Mr. Dunn, I don't think the state wants someone to be convicted or on probation for a crime that they didn't commit.
Absolutely, Judge. And just to even further the court's own point, I was speaking to another counsel about another trial date, and if this would like to proceed, Your Honor, we're ready if that is what the course of action needs to be.
So, counsel, if you need time to find this person he's saying, then, the plea is here. The plea will stand. I don't think the state is going to go back on their plea. And if you want to file a motion for a bond reduction, maybe they want to discuss that.
In the end, the judge makes a critical decision, not to rush sentencing, but to pause the case and give the defense time. This allows for further investigation, possible witness testimony, and even a chance to challenge the plea entirely. It's a reminder that the justice system isn't just about speed, it's about getting it right. But now the big question is a defendant telling the truth or changing his story too late? If you found this case as intense as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
You've been looking for, I can shed some light on this.
That's fair enough, Your Honor, and I appreciate that. And in the alternate, I'll file a motion for bond reduction just in case, Judge. But
Okay.
I'm glad we can clarify that issue because I did not want him pleading something he didn't want to do either. But at the end of the day, it's his call. But we'll definitely strive to those days, Judge.
All right, we'll recall it. And then I've already accepted